everyone, and welcome to the Florida Mental Health Counselors Association webinar entitled The Counselor's Guide to Complying with the No Surprises Act. My name is Dr. Aaron Norton, and I am the chair of the Government Relations Committee for the Florida Mental Health Counselors Association, and also the Southern Regional Director for the American Mental Health Counselors Association. This is a webinar that we put together very rapidly because we were getting a large number of requests from people to get more information on the No Surprises Act, of course, which, you know, the running joke is that it's kind of surprised us all. I do want to also launch a couple polling questions before we get into the content, because it really helps me to get a sense of who's out there today, so I can kind of tailor some of the things that we talk about connected to this act. About 94% of you are licensed professionals. We have some interns, some students, some counselor educators. We have a large group today. We had almost 500 people register today, which was the maximum seats available. You can tell this is a much needed topic, obviously, for counselors in the field. As I kind of expected, the majority of you are in private practice, about 92%. I think that makes a lot of sense because for a lot of people who work in agency settings, there's probably somebody, you're probably not responsible for figuring out how to implement a law like the No Surprises Act, but private practitioners are going to need the most guidance, I think, in terms of how to implement the act. The majority of you are saying that you either have very little or no knowledge or just a little knowledge of the No Surprises Act. So you're in good company then, because we're here to try and help illuminate some information about this act. Okay, so let's dive in then. First thing is, most of you are probably members of the Florida Mental Health Counselors Association. We're a state chapter of the American Mental Health Counselors Association. If you're not a member, then I would very much encourage you to join, because short of your attachment to the associations, it's pretty difficult to get information about things like this. And I hope the information we provide today is just another example of why membership and participation in the associations is very important. About me as a presenter, I am the chair of the FOMCA's Government Relations Committee, the Southern Regional Director of OMCA, the national chapter, and the executive director of the National Board of Forensic Evaluators and adjunct instructor at USF. But I also am a private practitioner, so I, of course, had to figure out how to implement this law in my own practice. I don't have any relevant ethical disclosures, but I do have a disclaimer that's important. I'm a clinician, I'm not an attorney, so the perspective that I offer you today is going to be what other entities in the field are saying about this act and how to implement it. And I'll also provide some information about my own interpretation of that information and how I'm implementing it in my own practice. But that is no substitute for sound legal advice from a qualified attorney. And ultimately, I would encourage you to have an attorney who you can consult with in your own practice about this act and other relevant legal issues. We'll also tell you that I'd love to say that your malpractice insurance companies will be helpful. I know CPH and Associates very recently published an article providing guidance for their customers. My own malpractice company, HPSO, I just got off the phone with them about a half an hour ago, and they are still trying to come up with something because they're saying the information that they have thus far is fairly vague, but you can be looking for some more information from other malpractice insurance companies. We'll tell you what's already out there, though, today. Go through here. And then the big popular question for every webinar, how do we get the slides? So the handouts, the PowerPoint today will be available to you as a PDF handout, including with hyperlinks. So every time you see something like this, an underlined link, or even a word that's underlined, if you click on it in the PDF, you will be redirected to the original source of that information. To access that PDF, you can use this link here, integritycounseling.box.com/V as in Victor /no-surprises-act. Now I'm also going to attempt to copy this and paste it into the chat box right now. Let me do that real quickly here so that we make sure everybody has this. So what we're going to cover, we're going to give you a brief background of the No Surprises Act, so you understand the rationale for why this act exists to begin with, who it applies to, which is actually a controversial question right now. We're going to talk about good faith estimate notices, where you notify people of their right to a good faith estimate. And then we'll cover creating good faith estimates themselves and some of the ethical issues and legal controversies about this new act, and then some resources you can use to learn more. We're not going to be able to get into the weeds on some aspects of this act. There's a lot of information out there, and we're still trying to figure a lot of things out right now. But we're going to cover what I think is most important for you as a practitioner to implement this law in the here and now. I want to start by saying if you're confused, you're in good company. I mean, Trust Parma, which is a not-for-profit organization that really, I think, kind of elevates good ethical and legal practice among mental health professionals. They wrote a very nice kind of an analysis paper, if you will, on the No Surprises Act. And I loved their opening. While it's clear that most of us were surprised by the No Surprises Act, it's not clear what those in independent practice settings or private practice settings should do to be in compliance. Many, including us, have opined various thoughts and recommendations, but because the Act itself is not written clearly, because it does not address all situations which independent practitioners face, absolute and fact-based complete guidance cannot at this time be given. That's frustrating. Even more so, it's of great concern because it negatively impacts us and our clients in time-consuming, potentially needless work, which can also have long-term consequences on our work as professionals. Because NSA went into effect before we could get additional information or even ask questions, we're faced with having to make certain choices and changes now, not knowing if those changes will need to be changed again, and not knowing how to protect our clients and professions best. That's more than frustrating. I think that's a well-put introduction to their paper on some recommendations on implementing this act in your practice today. So if you're confused, don't worry, we're all kind of confused. We're all in the same boat, but we're going to try and make you less confused today if we can. The background here is that 20% of emergency department visits for 20% of ED visits, consumers receive surprise medical bills due to receiving care from providers who are out of network. 9 to 16% of in-network non-emergency hospitalizations results in surprise medical bills from out-of-network providers. So I'm going to give you an example that I had a surgery done several years ago, went through my insurance, used an outpatient surgical center that was in network. They went over all the costs with me in advance and how much I'd have to pay and how much my insurance would pay. And then about a month after the surgical procedure, I get an unexpected bill because the anesthesiologist that was on duty that day was not in network. No one told me that. No one gave me a heads up that that was going to be the case. I had no idea that I'd have to be paying that bill later on, but it came later on because no one provided advance notice of it. And to deal with that problem, which is called balance billing, when a provider bills you for the balance of what insurance doesn't pay after the fact without having appropriately notified you in advance, Congress passed a law in December 2020. I think the issue is it's a very broad law, so it covers people that really weren't a part of the problem. Like in my opinion, private practitioners providing psychotherapy and mental health services to people on an outpatient basis. This really wasn't our problem, but we're sort of caught in the dragnet. That's my opinion anyway. Now, an interim rule was issued in July of 2021, but that interim rule didn't really seem to at face value apply to private practitioners. It wasn't until September 30th, basically October, that a second interim rule was passed on how to implement this law in the federal code. And remember that the Code of Federal Regulations, the rules and regulations you see there, they are expected to be adhered to just like federal law. And the penalties can be very similar or identical to what happens if you break a federal law. Those rules are how the federal law is essentially being implemented. This second interim rule established an independent dispute resolution process and required good faith estimates for uninsured or self-paying individuals. And that's the part that really started to perk the ears of private practitioners. Then there was a third interim rule in November that dealt with prescriptions. And then what you saw is about a 2-week period in December when the various associations are scrambling to try and get some information out to its membership. The APA on December 10th, the Clinical Social Work Association on December 14th, the American Association of Marriage and Family Therapy on December 21st, the American Counseling Association on the 22nd, the American Mental Health Counselors Association on the 23rd, and then the law went into effect about a week later on January 1st. So you can see that this was quite a mad rush to try and get information out to people. And this law already went into effect. It went into effect 6 days ago. So this is day 7 of the new law. These laws, or these codes, are published in 45 CFR Part 149 in the federal code. And there's a link to that code here later on for you to access it if you'd like. Okay, so that's the background. Now the scope of this law, who it's supposed to cover, well, it's supposed to cover to provide standards for healthcare providers and facilities, as well as providers of air ambulance services, with respect to surprise medical bills. So the big question is, are mental health professionals providers? Well, I'm just going to rush to the answer. Yes, of course, we're healthcare providers. If you're a licensed mental health professional in the United States, you're a healthcare provider. And so certainly it seems to me that we are part of the scope of this federal law. It doesn't say only if you work for a hospital. Now, there are people arguing that this law does not apply to private practitioners. And I can understand why that argument would be made, because there's a lot of confusion out there right now. When you look at the code itself, what you see is there are different subparts, and these different subparts apply to different entities. Sometimes you might go online, you might Google No Surprises Act, you might read an article, and that article was written about Subpart E primarily. So it only talks about facilities. And you might think, well, this probably doesn't apply to me as a private practitioner. Or maybe you Google it and you find an article that was written on October 1st, or I'm sorry, on September 15th, for example, and it doesn't talk about private practice. So you might think you're not covered. But then again, that was before the second interim rule was passed on September 30th. So you really have to be careful what you're reading out there. And you really might want to go back to the code itself and see for yourself what that code says. And I think Subpart G is especially the part that's really going to apply to private practitioners. I'm not saying that there's nothing in the other sections that couldn't hypothetically apply to us, because that's not true. I know there are parts of the other sections that do apply to us, but this part, Subpart G, is what we're mostly going to be focusing on today, because that's where the bulk of our requirements really come from in a private practice arena. Now, there are definitions provided in the law itself, like healthcare facility as a hospital, hospital outpatient department, critical access hospital, or ambulatory surgical center. Now, the problem is they put this definition in there, but in other places in the code, they'll say healthcare facilities such as hospitals, et cetera, implying that there are other healthcare facilities not included in this definition. And I've heard 2 attorneys present on this act and say that they believe that this term includes private practice groups. That's kind of subject to interpretation. But what I think is a lot less subject to interpretation is this, the definition of a provider. Because a healthcare provider is a physician or another healthcare provider who is acting within the scope of practice of that provider's license or certification or applicable state law. So if you're a licensed counselor, you are a healthcare provider. And yes, indeed, if you're providing psychotherapy, you're acting within the scope of practice of your license or certification under applicable state law. So I do not see how it's possible that you would not be considered a provider by this definition in the law. Now, you can be a participating provider, meaning you have a contractual relationship with a particular healthcare plan, or you can be non-participating, but you're still a provider. Now, to further delve in, though, and get more specific, CPH, which is a popular malpractice insurance company for counselors, recently put out a guideline to its customers, and they very clearly think that this law applies to private practitioners. In fact, they say the NSA builds off of that and asks the private practice practitioner to provide further formal disclosures of anticipated fees. They think we're included in this law. Trust Parma, a national nonprofit membership organization to support psychology, mental health, and allied health professionals, promoting education, risk management, and practice management, includes private practitioners as providers that are impacted by the act, and they give very specific guidelines for what you should do as a private practitioner. Now, I've heard people make the argument that, well, Aaron, the American Dental Association, they put out a notice saying that private practitioners who are dentists aren't regulated by this act in most cases. So wouldn't the same be true for us? Well, if you read their conclusion, you see that their reasoning is that dentists are providing services that are not covered under group and individual healthcare plans. That's why when you buy insurance, you buy a separate dental plan, and that's what you use for your dentist. This same argument would not apply to us, because the CPT codes that we use in our work, 90791, 90834, 90837, and so on, 90847, those are psychotherapy CPT codes which are covered under individual and group health insurance plans. So I don't think that logic would extend to us. That's my interpretation. It seems to be the interpretation of many others. And if you look at the associations, even though sometimes they're going to be a bit vague because we're still getting information, you'll see the ACA, they talk about behavioral health care providers. They don't say only those working in hospitals or in agencies. And the same for APA. What providers and what services are subject to this rule? Providers defined broadly to include any healthcare provider who's acting within the scope of their license. It doesn't say, unless they work in private practice. And the same for the American Association of Marriage and Family Therapy. So I really don't think you're going to see any authoritative source out there claiming that private practitioners are not covered under this law. But, you know, it could be. And there could be a new rule passed tomorrow, for all I know, that could conclude that private practitioners are excluded. But as of right now, it doesn't seem to be that way. And that seems to be the consensus among most experts that I've reviewed, whether they're attorneys or they're malpractice insurance companies or associations or groups that specialize in providing quality care in private practice. So with that in mind, let's dive in and look at what your requirements actually are under this act. So for Subpart E, this part is about balance billing at facilities. Again, I kind of interpret facilities to mean a hospital. Oops, sorry. Let me go back a space here. I have interpreted facility to mean a hospital, outpatient department, critical access hospital, an ambulatory surgical center, because that's the definition in the statute. But I do see places where you could argue otherwise, because they'll say such as these things in some other places in this subpart. But some people think this applies to group private practices, some people don't. Nonetheless, we're going to tell you what it says. Subpart E says that if you're an out-of-network counselor, or actually an out-of-network healthcare provider, providing emergency services at an out-of-network facility, then you can't charge clients more than the contracted rate for emergency services. And actually, I'm going to tell you, yeah, okay, so that, scratch the last sentence I just said. I'm not going to tell you anything more about that. That is what it is. So if you're an out-of-network counselor in an out-of-network facility and you're providing an emergency service, you're not allowed to charge clients more than the contracted rate for their insurance plan for those emergency services. So if they show up for an emergency, they've got Florida Blue, and you're in an outpatient center, and that outpatient center doesn't cover, isn't a Florida Blue provider, you still can't charge them more than their own insurance rate for that service. If you're an out-of-network counselor in an in-network facility, you can't charge a client more than the in-network cost sharing amount without having provided certain specific forms of advanced notice, whether it's an emergency or not. And also, these facilities have to post a notice with certain mandatory components on their websites, as well as, for example, in their lobby, someplace that's very apparent and noticeable about protections under this act. So again, this slide probably doesn't apply to most of you, but I put it up here anyway, in case it does for some people. Let's move on to the next subpart though. Subpart E, or Subpart F, establishes an independent dispute resolution process. Not going to say much about this today, but I'm going to give you the gist of it. The gist of it is this. If you give somebody a good faith estimate, and then during the period of time that good faith estimate covers, you end up charging them at least $400 more than what you originally estimated, then the client can dispute the charge. And then there's an independent entity that essentially gathers information and determines, whether they do owe that money or whether they don't owe that money to you. That's the very short version of the independent dispute resolution process. We'll talk a little bit more about it later on. Subpart G, this is the part that I think most of you are going to be interested in today and most of you want to know about. And for this part of the law, we have a definition for healthcare facility. Let me just get this control panel out of my way for a second. There we go. And again, there is debate about whether private practice groups are covered under this definition. I kind of think they aren't, but this part though, healthcare provider, again, it's very clear. Here they reiterate their definition of healthcare provider. And to me, it's very clear that it doesn't matter whether you're in private practice or not, you're covered under this definition of healthcare provider in the second bullet point. When a client contacts a provider to schedule an appointment, the provider must ask whether the client has insurance, regardless of whether it's commercial or government funded, Medicaid, Medicare, TRICARE, etc. And if so, if they want to submit claims for their services. Now, many of you probably already do this. We already do this in my practice. And I'm going to say right now, before I go any further, my opinion is that this law requires those of us in private practice to do what legally and ethically we should have always been doing. But it just makes us do it in a much more structured, detailed, specific, and maybe micromanaging kind of a way that makes it kind of unnecessarily detailed, in my opinion. And with certain timeframes and parameters that we didn't used to be held to. So you might already do this, but if you don't, because hypothetically, if a client called your office and they just said, yeah, I want to schedule an appointment with, Aaron Norton, and we said, okay, great, we got this date and this time, here's how you do your paperwork, the fee will be $150. If the client doesn't specifically say that they want to use their insurance, then we weren't necessarily required by law to ask them whether they want to use their insurance. But now it looks like we are required to specifically and explicitly ask the client, A, do they have insurance? B, do they want to submit claims? It doesn't matter whether you even accept insurance or not. You still have to ask them those two things. As far as this law says, it doesn't say, unless, by the way, you are in a network with insurance companies, it just says you're required to. Second, if you find out that they are uninsured or they are self-pay clients, and most legal opinions I've read so far would add, if they have insurance, but you are out of network for that insurance company. If any of those things are true, then you have to provide them a good faith estimate of their expected charges. That estimate has to be written in a clear and understandable manner. It has to be prominent. Actually, you have to inform them of the availability of the good faith estimate of expected charges. And that informing has to be written in a clear and understandable manner and prominently displayed on your home page of your website, as well as in your facility, like your waiting room, for example. So you should have it on the wall in your lobby, and you should have it on your website as well. Literally, Go to the law yourself, check it out. That is what the rule says. So I'm not saying, this is extra stuff that you can consider doing. I'm saying this is literally the minimal requirement established in the federal code. And so in the place where scheduling typically happens, it needs to be prominently displayed, as well as on your website. So that's the notice that tells them that they have a right to a good faith estimate. We'll show you what that looks like later on. But also, the moment that you start talking about costs, you are obligated to provide them, there becomes an obligation to give them a good faith estimate that's individualized to that client within certain timeframes. Here are those timeframes. If the client's scheduled appointment is at least 3 business days away, so if a client calls you and they schedule an appointment for a week away from now, then you have 1 business day to get them a written good faith estimate. Okay. If their appointment is at least 10 business days away, then you have up to 3 business days to give them a good faith estimate. If they do not even schedule an appointment, let's say they just call up and say, I just want a good faith estimate before I even schedule, then you have 3 business days to give them a written estimate. So this is a client that hasn't even scheduled with you necessarily, but they just want an estimate. Now, people have asked, well, what if they don't ask for a good faith estimate? It kind of doesn't matter. The law doesn't say only if they ask for one. It just says you shall give it to them when they schedule or when they contact you and inquire. And then it even says that convening providers and facilities shall consider any discussion or inquiry regarding the potential costs as a request for a good faith estimate. So literally, the moment you talk money with the client, like, yeah, the cost will be $150. At that point, you are obligated, these obligations kick in, and you now must provide them a written good faith estimate. Now, that good faith estimate can include recurring items or services. So some people say, well, wait, so do I give a good faith estimate for each individual appointment before every appointment? That would take forever. No, you are allowed to do a good faith estimate that covers recurring items. Like, let's say you see a client every week and you want the good faith estimate to cover their weekly sessions. You can do that. But you should include those recurring items and services, and you have to have timeframes, frequency, and total number of recurring items or services specified in that document. These are not optional. These are mandatory by the rule. And you can't do it for longer than 12-month periods. You can't say, yeah, I might do therapy with you for 5 years. Here's a good faith estimate. The maximum time frame that you can give is a 12-month period. So let's say you see a client for 2 years. You give them a good faith estimate at the beginning that's good for 12 months. And then at the end of those 12 months, you give them a second good faith estimate for the next 12 months, and so on. That's like the maximum time frame that you can give per good faith estimate. It must be provided by paper or electronically, depending on the client's choice, unless the client specifically requests a verbal or oral notification. I will tell you, I would always put it in writing. That way a client can never come back and say, I never got one and I asked for one. You want to be able to prove that you created a physical document and you provided to them. That would be my recommendation. What must this good faith estimate have on it? It must include, now again, everything you see here is mandatory. It is not optional. These are the minimal requirements for a good faith estimate. The patient's name and date of birth, a description of the primary item or service in a clear and understandable manner, and the date the primary service is scheduled, if applicable. An itemized list of items or services grouped by each provider or facility, reasonably expected to be furnished. The applicable diagnosis codes, expected service codes, and expected charges associated with each service, and the name, the NPI number, and the tax ID number of each provider or facility represented in that estimate, and the state and office or facility location where you're going to be providing that service. and then 3 different disclaimers, which are clearly spelled out verbatim in the law, must also be included on that good faith estimate. So this is probably more than anybody's doing right now, right? And that's why I say it kind of takes what we should have already been doing, and it sort of like, puts it on steroids, kicks it up a notch. I would argue that given that if there's a discrepancy of $400 or more from what you give them in the good faith estimate, what actually happens during the time period covered by that good faith estimate, given that that's true, I would rather overestimate than underestimate. So if I'm going to do a good faith estimate for an ongoing therapy service, I'd rather assume that I'm going to meet with them more than I might end up meeting with them, so I don't run the risk of a $400 or greater discrepancy at the end of the year. That is my opinion, but you can do what you want with that opinion. Now, some definitions before I show you the good faith estimate. Diagnosis code means a code in the ICD, basically, the International Classification of Diseases. Remember that the DSM, all the codes you see in the DSM are ICD codes. In the DSM-5, those codes in parentheses that are alphanumeric, like F32.4, for example, those codes are ICD-10 codes. So if you're using codes that you see in the DSM, you're fine if they're the ones in parentheses, the ICD-10. Service codes are essentially like your CPT codes, like 90791 for an initial appointment, 90837 for a 60-minute individual therapy appointment, 90847 for family psychotherapy, etc. You should already know all this stuff if you've ever done any work with insurance, but if you haven't, if you've only done private pay work, you may not know about those CPT codes. And I should have put them in this presentation. I didn't think to, but literally if you Google APA psychotherapy CPT codes, APA for American Psychological Association, they've got a great chart that shows you all the CPT codes. And it'll probably be the first hit on a Google search. Now let's get into some ethical issues about this good faith estimate before I show you it. The ACA Code of Ethics stipulates that counselors must inform their clients about fees and billing practices. So that's why I argue this law kind of mandates something that ethically we should have already been doing, even though we might have been doing it differently than the law now requires. The American Mental Health Counselors Association Code of Ethics reads, CMHCs communicate clearly with clients about the parameters of the counseling relationship. In a professional disclosure statement, they may provide info about expectations and responsibilities, their professional orientation and values, emergency procedures, supervision, and business practices. So this is something where we kind of ethically already knew that we should be doing to a degree. But there is an ethical concern that people have brought up. Client calls your office. They're a new client, never seen you before. I'd like to schedule an appointment with Aaron Norton. You now have to create a good faith estimate, and you have to get it to them within 1 business day, unless their appointment is 10 days or more away, in which case you have up to 3 business days. How do you include a diagnosis on a good faith estimate for a client that you've never seen before? Is it ethical to diagnose a client you've never seen? I don't think it is. I mean, the ACA Code of Ethics says counselors take special care to provide proper diagnosis of mental disorders. Assessment techniques, including personal interviews, used to determine client care, are carefully selected and appropriately used. How have you done that if you've never met with the client yet? The OMCA Code of Ethics says clinical mental health counselors utilize educational, psychological, diagnostic, and career assessment instruments, interviews, and other assessment techniques and diagnostic tools in the counseling process for the purpose of determining the client's particular needs. They base their diagnoses and other assessment summaries on multiple sources of data whenever possible. You can't do that if you haven't met with the client yet, right? So how do we get around that when the code specifically says that diagnoses are included in the good faith estimate? Well, I think the key term is applicable diagnosis codes, which to me infers there should be an end quote mark right here. But to me, that infers that there's a such thing as not applicable diagnosis codes, or that maybe sometimes, there is no applicable diagnosis code. Well, remember, a diagnosis code includes are those codes from the ICD, and again, the DSM includes ICD codes. Remember that in the DSM-5 in Chapter 2, the biggest chapter of the DSM that has all of your information about the diagnostic criteria of all the different disorders, it includes a final chapter called Other Conditions That May Be a Focus of Clinical Attention. Most of those are what we call Z codes. These are codes that are not disorders, but they are describing circumstances where somebody may come in and need some help. The APA, the American Psychiatric Association, officially decided that it's okay to use the ICD code Z03.89 that refers to no diagnosis, which means what I'm doing in the first good faith estimate, this is how I'm doing it. When a client schedules their first appointment, our office worker creates the initial good faith estimate. It includes Z03.89 no diagnosis because there's none made yet. And then it has 90791, the CPT code for the first appointment. After the therapist meets with them for the first appointment, the therapist creates a second good faith estimate for their therapy services. And that's where the code may look different, because by then they've met with the client, they might at least have a provisional diagnosis. Now, for those of you who don't diagnose disorders, or you maybe are working with a client who doesn't have a diagnosable disorder, remember, there's a million Z codes. There's a Z code, for example, for relational problems. There's a Z code for parent-child relational problems, problems with spouse or intimate partner. There's a Z code for psychosocial concerns, for employment-related concerns. There's a Z code for everything. And if you want to, I've got a 1-hour video that shows you all about those Z codes and how to find them and use them. So check that out on my YouTube channel if you'd like to get more information about them, so that you can consider that when you're creating these good faith estimates. Now, Trust Parma, in their guideline, they recommended either writing to be determined for the diagnosis for the first appointment, or using the code R69, illness unspecified. I just don't like doing that because I don't know if they have an illness yet. So I don't really want to say they have an unspecified illness if they maybe don't. I would rather just say I've got no diagnosis right now and have a code for that. But that's just my opinion. But you've got a couple ideas on how you can deal with this ethical dilemma on this slide. Now, here in Florida, Florida law requires us to keep records, and it includes a statute and a rule that is just as applicable as the statute that says that our records should contain diagnoses and financial transactions. And so again, law kind of already required some of these things, just not in as great a detail. Now, I've had private practitioners say, I don't keep notes. Terrible idea for lots of reasons. One of them is it's illegal, though, because this statute and rule doesn't say unless you're in private practice or unless you don't take insurance. All of us, we're all required to keep records. We're required to keep records including diagnoses, progress on treatment, financial transactions, and fees being assessed and collected. All of that should already have been going on. Now, on this slide, you can click on either of these two PDFs to download the government-provided example of the notice of right to good faith estimate that you have to post in your lobby and on your website, and an actual good faith estimate template. I do not like their template because it's too complicated for my environment, because it includes pages like, well, what if you have an out-of-network person who's going to do their anesthesiology or their physical therapy? It's really more, some of the pages of their good faith estimate are really designed more for hospitals. So it's not as applicable to my more simple setting. So I will show you the template I created, which covers everything the law says I must have, but it doesn't have anything extra that I don't need to have in my setting. And I'm going to give you access to those templates. This is an example of what the good faith estimate notice looks like. This one comes verbatim from the federal government. And this is the kind of thing you'd want to post in your lobby and on your website. You have the right to receive a good faith estimate, and here's what it should include, and make sure they give it to you within at least a business day. And by the way, if they end up charging you $400 or more beyond what they estimated, then you can contest it, and here's how you can get more information. That's the basic the basic requirements of the good faith estimate notice. But the good faith estimate itself is a little bit different. So here I'm going to back out of the slides and I'm going to actually pull up my templates. Remember I said I do two. I do one at the intake. Literally, the office worker does this one. The office worker is going to type in the client's name, date of birth. They're going to check off electronic or mail. We prefer to share it with our clients through the electronic portal so we can prove that it was shared with them very easily that way. And because it's convenient and easy to do because we have a portal in our practice. But theoretically, a client could say, I want it mailed to me, which I would prefer not to do. And then we put in our office worker puts the date of the initial appointment. We've already got the code for the initial appointment, 90791, diagnostic interview. The diagnostic code is the no diagnosis ICD code. Quantity is 1. Here's the cost, the total cost. And then our office worker checks off which therapist in our practice is providing it. Notice we have the NPI number and tax ID number, just like the law requires. Notice we have the name, address, location, contact info for the location, but also notice I put or via telehealth. So even though the therapist is here, the client may be online. I've got that in here. And then these are the disclaimers verbatim that the law requires us to have in the good faith estimate. I've condensed it to one page. And when you download the government's version, it's like pages long. It goes on and on. So I took just the minimal things the law requires, simplified it for my simple environment where we don't have multiple providers working with the same person. And here it is. You're free to take it, modify it to meet your own needs. It's there in the handout folder for you. Second handout is, remember I said after the first appointment, the therapist has now met with the client, right? And now the therapist is going to do this one. And they're going to put in the client's name, date of birth, electronic or mail. And notice it says, depending on our progress, I expect that my care of you will require continued weekly therapy sessions continuing through the end of the year as follows. Now, let's say that you know you're only going to work with a client for 3 months, and you are just 99% confident about that, and you know you won't see them more than once a week, then you can change this however you want. I'm just being on the safe side because sometimes you just don't know how things are going to pan out. And I'm just going to sort of assume I'm going to see this person for the maximum amount of time that the good faith estimate can cover, which is 12 months. And then I'll see them every week. And then these are the two codes we most commonly use in our practice: 90837 for 60-minute individual therapy appointment, 90847 for family therapy. The therapist can put in the diagnosis code, the cost, the quantity, the amount, the total down here, check off which therapist it is, and bam, you're done. Couple minutes, quick and easy, good for a year. All right, now, I know we have limited time, so I'm gonna move fast. These requirements do not apply to people with government coverage like Medicaid, Medicare, Indian Health Services, Veterans Affairs, or TRICARE, because they already have protections against high medical bills. That could change in the future, but right now, that's what the CMS website says. Now, one point I think is very important for us to mention is that this requirement for good faith estimates is not just about new clients that come in from January 1st on. This actually applies to all of your current clients. So any clients that you carried over from 2021 who are private pay, uninsured, or I would argue also out of network clients, they will also need good faith estimates. Which means if you have a practice where the majority of your clientele are private pay, you're going to be pretty busy generating a large number of good faith estimates at the beginning of the year here in 2022 in order to ensure that you're compliant with the law. There's no differentiation in the law between existing clients from the past, from 2021, and your new clients going forward. Now, somebody did hear me say that one time, and they thought that I was saying that they have to send good faith estimates to clients who they aren't actively seeing, like former clients. That is not true. This is only about current clients. So of course, if you are no longer seeing a client because maybe they were discharged or there's been a substantial gap in their treatment delivery, if they're not a current client, then I don't think you need to send them a good faith estimate. But any client on your caseload right now who you're providing services for should get a good faith estimate if they are private pay. If you're freaking out because you're not ready, in the Federal Register, they actually said, we realize it's unlikely that providers will be ready by January 1st. So we're going to, be discretionary about enforcing this for now. But then they turn around and say, on the other hand, nonetheless, providers and facilities will be subject to enforcement action for failure to provide a good faith estimate. So bottom line is, if you're not already doing this, start doing it immediately, as quickly as you possibly can. Now, some of the controversies are people are speculating that this will push people to, or at least push facilities to become in-network. Some people are speculating that, this really, all this does is it makes things better for insurance companies and harder on providers, especially those of us in small and solo private practices who don't swing a big bat, because now we're having to put extra time and money and resources into solving a problem that didn't really start with us, a problem that's typically going to be more in hospitals and surgical centers and places like that. The American Medical Association and American Hospitals Association filed a lawsuit over one aspect of this rule because they think that it gives the upper hand to insurance companies the way the disputation resolution process is structured. So we'll see how that lawsuit goes. There is a petition at change.org that as of this morning had 15,300 signatures on it that would make private practice mental health clinicians exempt from the law. So if you are passionate about that, feel free to sign that petition if you're into that. It's up to you. We will get more changes coming. Everyone's repeatedly telling us that. They could announce a new rule tomorrow. Now, the big thing is they've been hinting, by the way, we're going to start requiring this for in-network clients. Remember that as of right now, you only have to do this good faith estimate stuff for a client who's private pay, out of network, private pay or out of network or uninsured, any of those three things. You don't have to do it if you have a Florida Blue contract and you're seeing a client through Florida Blue Insurance. You don't have to do a good faith estimate. But we expect that to change. We're probably going to have to do this for all clients across the board in the future. Now, specifically, here are a few examples of people telling us that that's probably true. So you can look at that later if you want to as well. Got lots of additional resources here for you to read more about this rule and about the law. Want to remind you, if you're not a member of UMCA or FOMCA, become a member and stay a member so that you can see new announcements as we continue to try and understand this law more and we continue to update you about changes. Because otherwise, how are you going to know? If you're too isolated in our field in private practice, how are you going to know when something changes if you're not connected to the associations? And again, here's my email address in case you have questions for me after today, anorton@flmhca.org, as well as information on the FOMCA office. And I've got all the references from today in here as well. So having said all of that stuff, I know we moved at a fast pace. I want to go to the questions box and see if there are some questions that I can answer in the remaining 5 minutes or so that we have here. If you're out of network, how do you know the cost sharing amount? Also, the insurance itself says that they have no commitment to pay. That is a great question, Jacqueline. And this is something I don't know the answer to yet. If they are out of network, I don't know yet if we're obligated to try and verify their out of network benefits with the insurance company and then calculate how much the insurance company is going to reimburse them. I don't personally believe that is the case. I think that you would just quote your private pay fees And then you can either submit claims for them to get reimbursed by their insurance company, or they can submit super bills that you provide them to try and get in reimbursement. I don't think that you're obligated to figure out how much their insurance company is going to reimburse them. But that's just my opinion, and I can't tell you that I know that that's 100% true yet. Next question from Jenny. How does this apply to group practices with LMHCs that are in network, but registered interns in the same practice are self-pay only? So that's a great question. I think part of it would involve, are you billing people as a group, or do you bill people as individual practitioners in that facility? So to make things more complicated, there are 3 private practice models in the literature that I've seen. One private practice model is solo practitioner. It's just you and you only. Obviously, that doesn't relate to your question, Jenny. Second private practice model is an incorporated group. This is when you are an employee of a private practice, a group private practice, and the practice is billing them. In that case, you're going to have to use the more sophisticated templates that the CMS published, I think, that show you, well, like if you're working with someone who's in network, then, well, let me backtrack for a moment. In that case, I believe, the way it looks to me, that the out-of-network person will only be able to charge what the in-network contracted rate is. So if you're billing as a group, and you are as a group in network with that insurance company, but the specific provider working with the client is not in network, then I don't think that provider is allowed to charge more than the facility's contracted rate with that insurance company. So I believe that is probably the short answer to your question. The third model, though, is a shared expense group, and that's when there is no group billing and maybe not even a group tax ID number. There's just a bunch of independent, self-employed private practitioners who come together and like share expenses for their facility or something. And that to me is a gray area right now that I couldn't tell you, and you'd probably want to consult with an attorney on this question. Elizabeth, as you go through, can you point out which sections apply to nonprofits and or CMHCs? So I believe everything that I've told you about today is going to apply to nonprofits and CMHCs, because the subpart that has to do with balance billing, I think pretty clearly would probably cover nonprofits. And then the individual practitioner stuff is going to apply also, because your good faith estimates have to include the individual practitioner's information. Hopefully that wasn't too confusing sounding. I think a lot of us are doing video sessions. How does that apply? Like I said before, when you do the good faith estimate in the section where you have to give the location of the service, I give the location I'm at, my office, and then I put in parentheses, or via telehealth. That's the best I can think to do right now. I've never seen any other guidance so far from anybody on that question. What if different therapists in an office charge different fees? Then you would display their different fees on that good faith estimate. So in other words, if the client's going to work with, let's say you have, Sue and Bob, 2 therapists, Sue and Bob. Sue charges $200, Bob charges $150. If the client's working with both of them, then the good faith estimate should have both providers and both of their fees and the number of sessions each provider is expected to do, and then a total amount. If the client is only working with one of them, then it would have that one individual's fee on that form. Let's see what else we have here. Jill, I don't have my own website, just a Psychology Today page. So it does say in the rule, like something like if applicable about the website. So if you don't have a website, you don't need to put it on your website. Tom, must one display their fee schedule when the office is only online? What I would do in that case is on my website, I would have the good faith estimate notice that's required. And I would also, you still have to create a good faith estimate for the client. So that certainly will have your fee on it when you give them that. Good faith estimates, must they be in writing, or can you give them a verbal? So remember, it says it's weird because it says you must put it in writing, but then it gives an exception unless the client specifically requests that it only be given orally. My advice to you is to just always do it in writing so that there's never a debate about whether you did it or not. So a client can't come back and file a complaint with HHS and then you have to reimburse them a bunch of money because they're saying you never gave them a good faith estimate and you're saying, well, I gave it to them verbally and that's all they wanted. I would recommend doing it in writing, but technically it does say if they request specifically that it be oral, then it sort of gives you an option to do that. But it doesn't allow you to ask them if they just want it orally. That's the way it reads to me anyway. If they did not make an appointment, how can you assume an estimate would be needed? Because the law tells us to. So if a client calls you and they say, hey, I'm not ready to schedule yet, but I do want a good faith estimate, then you got to give them a good faith estimate. If they call you and say, maybe I'll schedule one day, but they don't ask for a good faith estimate, then I guess technically you wouldn't need to give them a good faith estimate in that case. Aaron, after the phone call, it's not clear about clinical issues, how to create good faith estimate. I'm not really sure what you mean, Aaron, but remember, after the phone call, the way I'm doing it in my practice is we give them a generic, just one appointment good faith estimate for the initial appointment. And I think you have everything you need for that. You can put a no diagnosis code, the date of the initial appointment, the expected fee, etc. After the initial appointment, hopefully the therapist has enough information to provide a second good faith estimate for the actual ongoing therapy. Jody, how are we supposed to know how many sessions they'll need without even doing an assessment? Again, I think what I just said a moment ago kind of answers that question. I recommend doing one up front for the first appointment, and then after your evaluation, do a second one for the number of appointments thereafter. That would be estimated. Can you do the GFE for less than 12 months? Yes, you can. You can do it for every 3 months or whatever amount of time you want, Nicole. It's just the maximum is 12 months. Mateja, how can we provide a diagnosis if we've never seen a client? I think we've covered that pretty thoroughly. Are we going to have a copy of the PowerPoint? Yes, we do. Hey, Rama, how do I get a diagnosis code? I think we covered that one also. Oh, we're out of time. We're in overtime here, actually. So I know you all probably have to go. If you didn't get your question answered, then just send me your question. Again, my email address is anorton@flmhca.org. I hope this was a good start. I'm sure you'll be hearing more from us about this topic. In the meantime, send us your questions. We'll see what we can do to help you out. It's been a pleasure, and I wish you all a meaningful weekend and a very simplified process of complying with this new law. We'll see you next time.